Hello, my name is Doug Smith, and welcome to the 5 October 2012 edition of Portsmouth This Week. My guest again this week is Gary Crosby, the town planner. Welcome, Gary.
Thank you.
We started a conversation last week on the zoning process, and as I walked away, I kind of was thinking to myself, geez, this whole thing sounds very simple and logical. You have two parts to the zoning ordinance, the ordinance itself, which describes the different kinds of zoning and what you can do and what you can't do, and then you have a map in which you lay down these things on actual properties. But then it seems like as soon as we said that last week, it immediately became pretty hard again.
Exactly.
And maybe we can get at this by trying to see how did this zoning system evolve here in Portsmouth?
When I was here, when we were talking last, I said that I thought that the zoning ordinance was the grandchild of federal enabling legislation and the child of state enabling legislation, 1991. But we've had zoning in the town of Portsmouth much earlier than that. Our first zoning ordinance was in 1965. Interestingly enough, the map for that ordinance, basically they said all of the town of Portsmouth is residential, with the exception of a general business district and some areas that they drew on the map, which were industrial and some open space. The general business district ran on East Main Road it was both sides of the road, basically 500 feet back from the roadway, from Union Street up to Park Avenue and then out to the Stone Bridge, and then on West Main Road from Union Street to Mill Lane, I think, on both sides of the road. So that was our general business district. In 1980, there was a complete rewrite of the zoning ordinance, and what we have in our ordinance and the map today pretty much came from that 1980 effort. There was, Doug, you had asked, when did this happen? Was there a group of people that sat around a table and said this? And in fact, that is the case. And I know their names, and I'm going to hunt them down. There are four things happened in 1980 that are of significance. So one is that they took the residential district and divided it up into sort of sub-districts, R10, R20, R30, R40. So, and that has to do with minimum lot size. So way down in the southern part of town, Wapping Road area, there's actually some R60, no, there's R40 down there. It's 40,000 square feet, basically 1 acre minimum lot size. Up in the north end of town is R10, 10,000 square feet minimum lot size. Now, if you're at all familiar with the lots in Island Park and Portsmouth, you know that many of them are far less than 10,000 square feet. So, and we'll talk about that.
We have a copy of the zoning map, and Bob, you may just want to take a look at this real quick, just to see that the different colors represent different kinds of zoning. I presume,
that's correct.
Right?
Yep.
And you don't have to stand it very long, but I just thought it's kind of interesting to see the patchwork that Portsmouth has become. Yeah.
So and you'll notice that the zoning map now, rather than, for example, the general business district was 500 feet on either side of the roadway. We have this is the second thing that happened significantly in 1980 was that Article 3 of the zoning ordinance describes the districts, and there is actually lists of plat and lot for each parcel in town is put into the zone, a particular zone. So with the exception of the residential zones, we don't list all the parcels in the residential zones only because there's too many. But for the commercial and industrial, light industrial and open space zones, there's actually a list of the plat and lots that are in those zones. So that makes it much easier for everybody, and you don't end up with lots that have split zoning, which is fairly rare in town now. The third thing was the land space requirements table, which laid out the minimum lot size, frontage, setbacks, lot coverage, building heights for each of those zones. It's a nice table that everybody can readily refer
Are
to.
these things consistent statewide? for example, or-
No, they're not. They're key
they're
to the
adopted
community.
locally,
Right,
then.
right,
Okay.
exactly. And then finally, they created the use table, Article 5. The famous Article 5 of our zoning ordinance is the use tables, and basically it lists as many uses as can be described, and then it's a table where each of those uses is either, for each of the districts, is either, it's a matrix, and the use is either permitted or permitted by special use permit or prohibited. So you can look down that table and see the use and see what's available for the district that you're in. Now, there is a provision also in the ordinance that says that use is not so listed. You can't use, we couldn't come up with everything, but use is not so listed can be brought before the zoning board of review, and they can make their decision based on uses that are as similar in the ordinance. So.
Okay, so it sounds like it starts to get complicated right about at this point.
Yes, it does. And the complication is that we have this nice, neat package for doing this. We know what the minimum lot sizes are and everything else, but we're taking this and we're overlaying this onto a landscape that has been, sliced and diced and bought and sold and since the early 17th century. So you have circumstances where, for example, somebody's got a 50-foot wide lot, and the side setbacks for that are 15 feet, so that leaves, times 2, that leaves them 20-foot wide to build a home. And so, so there are circumstances that are beyond the control of the property owner, and that's why for them to be able to do what they would like to do under the unique characteristics of the land. And so that's why the concept of relief is needed in the zoning ordinance, to try and accommodate, like I say, circumstances beyond our control. If you got a giant boulder in the middle of your lot, you can't build a home there, you've got to move it over here. And that's the way we accommodate that.
Are these, when zoning changes are made, are these things retroactive? Do they, let's say somebody, your example, 50-foot width, and they had a house on it that's footprint was like 30 feet.
Right,
and the ordinance was passed that, you need these 15-foot setbacks. How does that affect the homeowner that's already there?
Well, we have that's a very good question. And there's two provisions in the ordinance, or, topics in the ordinance that deal with that. One is called a substandard lot of record, and the other is a non-conforming use. Now, both of these are basically, with a substandard lot of record, it's a lot that was lawfully in use dimensionally at the time of the inaction of the adoption of the zoning ordinance. And so a substandard lot of record is allowed to, it can't meet the dimensional provisions of the ordinance, but it's allowed to continue. You can't expand without going to the board to get a variance, but it's allowed to lawfully continue. Now, a non-conforming use is the same. It's a use of land that was lawfully in existence at the time of adoption of the ordinance. And this is the classic concept of grandfathering, where you are allowed to continue the use, even, let's say, you have a blacksmith shop in your garage, or in a building that ends up being zoned residential, and you can't. It's a non-conforming use. You're allowed to continue to use that blacksmith shop unless you abandon that use for more than 1 year, and then the zoning would then revert to whatever the conforming use is, the residential or whatever.
Okay, but you probably could, but you couldn't expand.
No, you can't expand it.
shop.
Again, without, you can change it, you can expand with a special use permit, but as we'll discuss, there are a good many things that you have to demonstrate in order to get that permit, impacts to the neighborhood and so forth. So those two things, the substandard lot of record and nonconforming use, allow us to overlay this this scheme for regulating land use onto a landscape that's been previously settled. So, but then there are two things that, in order for somebody to be able to develop a piece of property or to expand their use, or and when they are non-conforming or substandard in as far as dimension is concerned, they need to come in front of either the zoning board of review or the planning board, and we'll talk about that a little bit, for what's known as a variance or a special use permit. Now, a variance and a special use permit are basically permission to depart from the requirements of the ordinance.
To do something that's not...
Right.
Yeah.
It's official permission to break the law, basically, or to operate outside of the law. And, you know, obviously, we need to be able to have this kind of relief. There are two types of variances. One is a use variance, and the use variances are very rarely granted, and for reasons that I will talk about. But
okay, this would be a commercial use of
right.
a residential property.
Right. I want to put a restaurant in, you know, a residential neighborhood or something like that. That wasn't there before. That wasn't a non-conforming use if you wanted to go in. So use variances are really rather rare. The other is a dimensional variance, and that is permission to encroach upon the setbacks or to have a building which is it's mostly to encroach upon the setbacks is a lot of what we see, because as you may have perceived, the whole north end of town is zoned R10. The minimum lot size is 10,000 square feet. When they did that, they instantly made 89% of the lots in Island Park and Common Fence Point substandard lots of record.
Yeah. Could we take a look at the map? That's the area there in the reddish.
Yes.
More or less?
Yes. So if you want to sneeze in as far as dimensional requirements of developing your property in those neighborhoods,
so that would be this area.
That would be this area here. Yeah. Okay. Island Park, Conference Point. Yeah. So they oftentimes somebody wants to put on a deck. They, you know, and a beneficial use of their property. They want to encroach upon the setbacks. They got to come and get a dimensional variance. So to get a dimensional variance, it's not just a matter of you going in and saying, I want to do this, and everything is dandy. They'll give you a variance. You have to demonstrate certain things, one of which is hardship. You have to demonstrate to the zoning board of review that due to the unique characteristics of your piece of property, you can't do what you want to do like everyone else in a similar situation, that because there's a giant boulder in your front yard, or there is right, or the lot is very small, sure, and you want to build a deck, you have to demonstrate that that it's a hardship, that is there's no reasonable alternative for you to be able to do that, to do this. And that it's more than for the board to deny it, it would be more than a mere inconvenience. It has to, you have to demonstrate that you've thought of everything and there's no other way to go about it.
So in the case of a deck, let's say, that's something I can understand.
Yeah.
In the case of a deck, you could say that there's nowhere else on my property that I could put this deck. Everybody in my neighborhood has decks.
Exactly.
It's not going to have any impact on anybody else.
Exactly. Now, that's precisely it. Now, there's another concept called least relief necessary, but I'll talk about that in a second. But you have to demonstrate, first of all, you have to demonstrate this hardship, and that there is no other way that you can go about it, and that you need to get this relief, need to get this permission to depart from the ordinance. You have to demonstrate that the hardship isn't self-created, that you haven't prior action, your own actions. You purchase a piece of property, for example, knowing full well that you can't build that you can't encroach upon the setbacks and then come and ask the board to do so. You have to demonstrate that it's not, the hardship is not self-created, and you have to. And then the board is going to want to look at your request and determine whether it's the least relief necessary. That is, the least amount of encroachment onto setbacks or whatever. That you go and ask them for, you want to build a deck that's 18 by 36, and they're going to say, well, I think you could probably get by with a 10 by 16 deck, and not encroach upon the setbacks as much. So that's least relief necessary. So to get a variance, you have to demonstrate hardship. You have to demonstrate that hardship is not self-created, and you have to make application for the least relief necessary.
Okay, now this goes to the Zoning Board of Review?
This is the Zoning Board of Review, that's right. They are responsible for issuing variances, special use permits, and doing appeals and that sort of thing.
Now this all sounds very complicated. Do people generally do this themselves, or do they try to get a lawyer to help them out?
Well, sometimes they get lawyers to do so. Oftentimes it can be fairly simple, and most people represent themselves. One of the reasons why I wanted to jump at the chance to talk about this is the Zoning Board of Review. Most people, when they come in front of the zoning board, they come in and ask for a building permit to build a deck. And Denise says to them, or George Madero says to them, no, I'm sorry, you have to get a variance. What's a variance? Why do I need that? So, and they end up in front of the Zoning Board of Review having no idea
what's going on,
why they're there, or what's, and in fact, for the board to issue this variance, they have to demonstrate hardship, and so oftentimes they're not prepared to do so. So the board has asked me to kind of put together some sort of a package or a letter or a pamphlet or something to help people to understand what it is that they need to be prepared for if they come in for a variance.
Well, we may be able to refer them to this video.
Yeah. Well, that's what I'm hoping, is that at least, and I know preparing my notes for this, it helped me organize so that I can do that for the board.
Okay, so that would be a variance. How about a special use permit?
A special use permit is, again, it's permission to depart from the requirements of the zoning ordinance, but in the case of a special use permit, you're not really concerned with hardship, as the board is not concerned with hardship in a special use situation. They're concerned with impacts around the neighborhood. And when you go in for a special use permit, they can't, there has to be, as I said in Article 5 of the zoning ordinances, the use tables, and we either permit uses by right, or we permit them by special use permit, or we permit them, or we prohibit them. So somebody can't come in and ask for a special use permit for something that is prohibited, but they can come in and ask for a special use permit for something that is permitted by special use permit. So there are, and so as I said, the board is really concerned not so much with you demonstrating hardship. There's no other reasonable use of the property. They're concerned with the impacts to the neighbors. And there are 10 criteria. The board has got to make findings that and you have to demonstrate to the board's satisfaction that what you intend to do won't have any detrimental use to the neighborhood. You won't encroach on their solar rights. You won't it won't be a nuisance. The safe vehicular access is there, you have to make the case. And this is, you asked about lawyers. For the most part, when people are coming in for special use permits, they're going to be hired. They're going to hire an attorney because these guys know how to navigate this, and they know how to. They demonstrate how to demonstrate to the board's satisfaction all of these impacts to the surroundings. So that's the difference between the two. Is the variance deals with hardship, the unique characteristics of the land, and the special use permit deals with impacts around to the surrounding neighbors.
Let's shift gears a little bit, perhaps, and talk about development issues, development projects. I've seen that somebody's going to pick up on the Clock Tower Square and develop the rest of that out, which I think will be great because it's a nice little place.
I agree.
How is that affected by the zoning process?
Well, as we said earlier, the variances and special use permits are handled by the zoning board of review. So-called land development projects, which are in our zoning ordinance, we have a category called residential open space development and another section that deals with planned unit developments, or PUDs. These are handled not by the zoning board of review. These are handled by the planning board. The planning board may ask for advisory opinion from the zoning board of review, but and the design review board, which is another board that I haven't talked about at all. The design review board is sort of a subcommittee of the planning board. The design review board is very much involved in these land development projects. So it's a different way of dealing with land use.
Yeah, and let me make one point too. In Portsmouth, at least, the members of these boards are basically volunteers, citizens.
Yep. They're appointed. They're appointed by the town council.
Right.
There are vacancies. There are provisions in the ordinance and in the subdivision regulations.
So they don't necessarily have to be lawyers or specialists or land.
No. It's really nice to have an engineer or an architect or a designer of some sort on the planning board, and from time to time we do have that. But for the most part,
applaud these citizens for stepping forward. It sounds pretty complicated.
It is a lot of work, they work hard at it. The land development projects. The typical, let's say you've got a 10-acre parcel and you want to do a housing subdivision. The standard way, if you wanted to just do that, the standard way to go about that is to figure out what zone you're in, what the minimum lot size is, and take that whole parcel and subtract 15% for the roads and everything, and then cookie cutter out as many lots as you can get on this 10-acre parcel at the minimum lot size, and then each one of those lots has to conform to the setback and minimum lot size requirements in the zoning ordinance. There's another way to go about doing this, and this is what these land development projects are all about. In the case of a residential open space, this is, I hesitate to use the word cluster zoning, but because it doesn't really describe what's going on here. But a residential open space development says we believe that reserving a piece of this property for communal activities, open space, recreation, agriculture, something like that is a desirable amenity. And so rather than just cookie cuttering the development out, the developer can do a residential open space development, which he's allowed to reduce the size of lots below the minimum lot size for that zoning district, in exchange for setting aside part of that land as communal open space. The benefit to the developer is he's got to build less infrastructure. His roads can be shorter. They can, the water lines can be shorter and so forth, and you can kind of put everything in one spot and have open space.
But the downside for the developer may be less properties to sell.
Well, yeah, no, he doesn't. The way it works is if you want to do one of these residential open space developments, first you do the cookie cutter version. You figure out how many lots you can
then you try to put
those
those
in
into
there.
a cluster.
And you're not allowed to have more lots, but they can be smaller, and so you can, as I said, save on your infrastructure and so forth. So. In theory, it sounds wonderful, but in practice, oftentimes what happens is the hunk of unused land off in the corner or that's wetlands or something like that gets designated as the open space, and the spirit of what we're trying to do here kind of gets subverted, and so. It's not great, and we've had a couple of them here in town, but that's. And this is all taken care of by the planning board. This is the other point I wanted to make. This has nothing to do with the zoning board at all. The planning board does this, and and particularly with a PUD, and I'll talk about this in a second. It's a very interactive process between the planning board and the developer.
And how does the town planner yourself get involved in these?
As an advisory, to the planning board.
Okay.
Oftentimes with a PUD. The planning board will set up a technical review committee, and I would certainly be involved in that.
Okay.
So it's advisory to the planning board.
We're going to be running out of time here again, but I do think, can you talk briefly about the plan unit development?
Yes.
And then I want to mention at least the comprehensive plan.
Sure. The PUD, planned unit development, is allowable in certain districts in the town of Portsmouth, and as I said, it's a method for developing a property. There's a minimum lot size. You can't do it on anything less than 4.5 acres. You can group together parcels under common ownership and develop them as a group. But it's a coordinated design approach. That deals with all aspects of the development, the roadways, the traffic and utilities, the parking, storage, lighting, the actual design of the buildings and the placement of the buildings. All of this, you're developing the entire parcel as a integrated whole. And rather than this cookie cutter approach.
So this can be kind of pre-planned.
Oh, it's all pre-planned. It's all down to the the nuts and bolts. Absolutely. The end result of this process of back and forth process between the planning board and the developer is a development agreement. It's a document recorded in land evidence records that outlines all of the benefits to the developer. There are surety bonds so that he makes sure and does what he says he's going to do. There is provisions for maintaining the landscaping and public improvements. We have 5 different kinds of planned unit developments.
We're going to have to go on. We're almost out of time. Could you, all of this, the zoning that is done in the changes to the zoning process relate to the comprehensive plan, which we're just in the process of starting to revise. Right. I understand it.
Yep.
How long does this process take? And
well, I've told the council that and I've met with statewide planning, and we've talked. Quite a bit about how extensive we ought to be with this.
Thanks very much. We've had Gary Crosby, the town planner, with us talking about zoning. Hope to see you next time on Portsmouth This Week.